These are things that are really rudimentary, simple for being at best legal practices that a lot of people don't get right. And I just hear the questions coming in from my clients. Hey there, and welcome to another exciting episode of the Conscious Counsel podcast with your host, Cory Sterling. That's me. I'm so happy that you've tuned in for this episode, and I'm really excited that you're here and excited to share some fun, helpful legal information with you. As always, the promise of this podcast is to provide information and stories to help you protect and grow your health and wellness business with both confidence and clarity. So confidence and clarity are the two things that we're about. I just want you to understand the basic things about law and the different legal issues that will come up as an entrepreneur in health and wellness. And that is my intention in creating these episodes. So this week's episode is a little bit different. I don't actually have a story, but I want to talk about the core legal agreements and how and where they should be used, because there are a couple of questions that I always get. And I had a call with one of my clients this past week, and on the call, he was actually asking the perfect questions in the simplest way. And for me, I've done this for 9 years. I've worked with more than 1,600 clients. So I know all of the answers are just automatic for me. But still, I think answering some of the basic questions are really important to help provide information to you. And I hope that you enjoyed and help and that it helps you. So the first thing, basically the crux of the call was, okay, hey, Cory, I've purchased these 5 core agreements from you, and now I need to know how to use them and where do they go. And so I just am quickly going to, in this episode, I want to walk through what the basic agreements are, where they need to be put, why you use them, and also talk about the timing of how everything should happen to be at best legal practices. So the agreements that we set the client up with were a privacy policy and a general health disclaimer. So this client was a health coach and is doing nutritional things and is providing a lot of lifestyle suggestions. Obviously, they're not diagnosing, they're not treating anything. They've completed a health coaching certification. They got a package of documents, they want to use them. And so their question was, where and how does everything go? Privacy policy. So the privacy policy is a really important document. This is where we outline the personal information of others that you collect. So if you have a mailing list, if you have any form of database, if you're holding any information of clients, first name, last name, email address, phone number, you need a privacy policy for all those things. Also, when you're using electronic payments, when you're collecting money with electronic payments, you're facilitating the transfer of your client, clicking a link, going to Stripe, going to PayPal, whatever it is, and sharing their information there, and you're responsible for that transference. So privacy policy in terms of service for the website always need to go on your website. It can be a header or it can be a footer, and it needs to be hyperlinked. So you need to say privacy policy in terms of service, click here. Awesome. That's the privacy policy. So very simple. We share all the third-party information, any third party that you're sharing with, all of the rules, making sure you're at best practices and following everything. The first question was, where does the privacy policy go? Privacy policy in terms of service has to be hyperlinked and clear to see on the website. Most people put it as a footer, which is acceptable. The second is a general health disclaimer. Now, a general health disclaimer, this applies only to health coaches, but it's really important because this is when you have a website and you're going to tell your story about your journey through health and how you were ill and how you healed yourself or how you learned how to heal and how you want to help other people do the same thing. Now, you have to be really careful about what health coaching related materials you post on your website. And a general health disclaimer basically says like, hey, all of the information that's on this website is for educational use. You know, these are my qualifications. This is what I can do, what I'm legally allowed to do. This is what I'm not allowed to do. This is what I actually do. This is what I don't do. And, you know, if you act on any of the information, if I'm sharing a story about, you know, my relationship with a particular food or a substance or a lifestyle approach, these are just personal anecdotes for educational purposes. No relationship is created between us, between coach and client through the information. All of that is called a general health disclaimer. That also is a footer on the website. Now, the next agreement that we'll use, and I get a lot of questions about, are waivers of liability. So now the question is, what happens with the waiver and when does it get signed and how does the process work and where should it go? So the thing about the waiver is that this is the document that has to do with someone signing away legal rights and agreeing not to sue you in exchange for you providing services to them. The waiver must be signed before you start working with someone. Full stop. Doesn't matter if you have a gym, if you're running a retreat, if you're health coaching, if whatever it is that you're doing, people have to sign the waiver before you work together. Because what the waiver says is, hey, we're going to be working together. This is what you're helping me with. These are the activities. These are the risks. This is what could happen. These are the damages and injuries that you could suffer. And before I allow you to participate in the services with me, you agree not to hold me legally responsible if one of the risks in the document outlined or things that we're doing together, if any of those risks materialize, you agree not to hold me responsible. The waiver has to be signed before payment is taken. And the big thing with the waiver is that it needs to be either someone needs to sign it, you need to print it, or digitally they can sign it, whatever it is. There's no difference between if it's digital or if it's signed in person. If you're just doing a checkbox, people have to have an opportunity to read the document. So there's a famous case in law where someone was checking out, buying something, a service, and it said, I agree to be bound to the terms of the waiver. There's a checkbox, they clicked it, but the document wasn't hyperlinked in the same line as that box. And then their defense was, well, the waiver is not valid because we never actually had an opportunity to read it. And that argument was upheld. So it's really, really important that with the waiver, people have an opportunity to read it before. You can show they had an opportunity to read it, and they still agreed to be bound to relinquish their legal rights. So waiver signed before you accept payment. The service agreement. So in coaching, this is a client service agreement. In retreats, this is a retreat participant agreement. For studio, this is a membership agreement. When it comes to these agreements, they also need to be signed before you accept the payment. So just think of it in a really simple way. I've got this thing that I'm offering you. You agree to be bound to the terms of working together that are outlined in the relationship. And then you agree to be bound, it's legally binding, and then I accept your money. I've had a lot of issues in the past where clients have not, where they mess the order up, where they would provide the services to someone and then try to get the agreement signed. But the legal excuse and argument, if something goes wrong, is, well, I only agreed to these things afterwards, and I didn't know before what I was getting into and what the terms of the relationship were, and therefore it's not clear, and I should be allowed to get out of this contract, or I'm not bound to the terms. And that also will get upheld. So in a most basic sense, when it comes to agreements, is you always want to go through the process of, you give someone an opportunity. Hey, this is the relationship we're going to have. You've had an opportunity to review this agreement. You sign and agree to be bound by it, and you make payment, and then I provide the services. That's how it always should go. The last agreement that is really important is a social media disclaimer and a media release. So this is for any information that you share or post on the internet, specifically on your social medias, LinkedIn, YouTube, Instagram. And it also relates to any photos or images you might use of other people, right? So you want people to sign a media release so that you can use their video, their image, their likeness for promotional purposes or for marketing purposes, and also that you can talk about the things that you want to talk about on social media. So my client who I was doing this big review with asked me the question. They're like, well, where do I put the social media disclaimer? And there's two answers. One is, if you have a link tree on your Instagram profile, you put it there. If you have a YouTube channel or a podcast, you put the disclaimer a little bit in the bottom there, and make sure that it's there every time. And that's the best way for us to be able to show, hey, included in my link tree was opportunities to work with me, buying sessions, free download, and my social media disclaimer. And alternatively, in the event that you don't have a link tree on your Instagram profile, you want to link it to the website where people find your Instagram from. So privacy policy, general health disclaimer, social media disclaimer as well on the bottom. A media release should be signed or agreed to, but a media release usually will lump it in with a service agreement. So it's all in one checkbox or one signature, and we have the service agreement. Hey, this is what you're paying for. This is what you're getting. These are the qualifications. This is what's included. This is what's not included. This is our cancellation policy. These are our behavioral expectations, everything that's related to that. And in addition to that, we just add it as part of the service agreement, the media release. Hey, cool, I can use your image. I can use it for marketing purposes. You allow me to use your image. So I hope all of that makes sense. It's sort of taking a lot of complex legal concepts and putting it into a short example. But just to summarize, privacy policy, in terms of service and a general health disclaimer for health coaches will go on the bottom of the website. A social media disclaimer, which protects you from going on social media and talking about all the things and whatever it is that information that you're sharing, also will go on the bottom of the website if you do not have a link tree for your social media. Waiver of liability must be signed before you provide services or accept payment. Service agreement must be signed must be signed before you accept payment, and then a media release will usually be lumped in with a service agreement so that you have everything in one place and it's easily taken care of. If you need any support with legal services, we're super excited to support you. You can just send me an email at Cory, Cory, at consciouscounsel.ca. And I look forward to supporting you. And these are things that are really rudimentary, simple for being at best legal practices that a lot of people don't get right. And I just hear the questions coming in from my clients. So I want to share them with you and provide the answers in an easy way. I hope that you have a wonderful week. And whatever you do, make sure you work with a lawyer that loves you. Peace.